I'll tell you what, and I'm excited about our guest today.
Very.
We've got Brian Hufford joining us. Brian, did I say that right?
You did.
Okay, he's an attorney and a partner with Zuckerman, and is it Spaeder LLP? Is that right?
Yes, it is. Good pronunciation.
All right, very good. And looking forward to it. We're going to be discussing mental health insurance and your rights. We're also joined by Patty and Steve as they get ready to kick off another great episode of the Mental Health Moment, brought to us by Acadia Healthcare. Don't miss another minute and don't suffer another minute. Reach out for the peace of mind. Contact Chris Getz at Acadia Healthcare, 469-400-7499. All right, Patty and Steve, I'm going to turn this thing over to you. I know that, Steve, you've got a great background in this as well, and so I'm really excited to hear what it is we can be doing better in mental health insurance and all that goes with that.
Absolute. Good morning, John, and thank you, but my credentials don't even compare,
So we're going to start it off this morning with Brian's background. Tell us about the kind of law that you specialize in, Brian.
Yes, hi. First of all, I want to thank you for having me on today, and I appreciate the fact that you guys have this show to deal with and promote this very important issue. I'm a healthcare attorney. I'm a partner at the firm Zuckerman Spaeder out of its New York office. Zuckerman is based in Washington, D.C., also has a couple of offices, one in Tampa, Florida, one in Baltimore. The firm does a lot of commercial litigation, white-collar crime defense, et cetera, but I head up the health insurance practice. And what that basically means is we represent patients and providers in challenging improper denials or reimbursements from insurance companies. So really what my practice is based on is litigation against insurance companies, suing them to try to make sure they cover appropriately, and providing various consulting to help people get the care they need. We've got cases all over the country. It's a very active area. Not a lot of attorneys do it because these guys we're suing are big boys in the country, have a lot of money, and they'll do whatever they can to defend their practices. But it's an important practice because we are trying to challenge their policies that lead to denials. And probably half my practice is mental health care and behavioral health because that's such an important area. And it's also an area that is sort of in some ways, low-hanging fruit for the insurance companies because they believe it's an area they can save money by denying coverage in many ways and restricting coverage. And so that's become a significant target of our practice.
So, Brian, you were one of the lead attorneys in the Witt versus United Behavioral Health Care case. Can you talk about that situation and the results that you received?
Yes. In this case, and it's really what is sort of the foundation of what we're doing right now, we brought the case against United Behavioral Health, which is the largest behavioral health administrator in the country. And what that means is that UBH, United Behavioral Health, it basically works either on behalf of most of the United Healthcare companies' plans, which is the largest insurer in the country, or sometimes it can also work with other insurance companies that hire it. But it specifically focuses on behavioral health services, meaning somebody who has claims for mental health or for substance use disorder. And what United does, UBH does, when a claim comes in, it makes the decision what is medically necessary or not, and then decides are we going to cover it or not cover it. But in doing that, it applies internal guidelines that it uses to determine itself what we are going to use to decide is this covered or not covered and what's medically necessary. And frequently, that is what has allowed it to get away with what it's doing, in our view, in terms of improperly denying care. Because when it's relying on guidelines and it basically makes the decision it doesn't comply, this patient who comes in wants residential treatment for an eating disorder, for example, and they'll look at their guidelines and say, you don't meet it, so therefore we're not going to approve that coverage. If there's a challenge to that, you go to a regulator, you go to a court, and they basically say, well, is what the insurance company's done, was it reasonable? They basically look at it and say, well, they were applying these guidelines properly, therefore we're going to uphold that denial, and the person is effectively left without coverage. What we decided to do in the Witt case is actually challenge the validity of those internal guidelines. We argued that those guidelines were overly restrictive and were designed to give them a foundation for denying care improperly. And what it really comes down to is what the plans provide. Everybody has a plan. It's really like a contract that says here's what coverage you're going to get. and virtually every plan says you're going to get medically necessary care defined to mean what is generally accepted in the medical community. And so the real question comes down is, what does that mean? And that's what the guidelines are for, is to show how UBH is defining generally accepted standards. And what we sued United for was to claim that their guidelines were inconsistent with generally accepted standards. And to probably put it succinctly, they were focusing solely on what we would call acute care, meaning only the most severe cases. If you were very acute, actively suicidal, unable to get sober, risking your life, we might be able to put you in for a week or two. But as soon as you got more stable and we think that you're not immediately suicidal, we're going to say you don't need to be in here anymore, and we're going to kick you out. But that's not medically necessary, because medically necessary is what's the best way to care for you. And that can be chronic conditions with mental health issues, and it could be long-term. And so what we were able to do by bringing a class action, and if you have questions about that later, I can certainly go into it, but with class actions, you have a handful of people. We had 10 plaintiffs who represent their own interests, but they also say, we have similar issues to everybody else around the country with similar problems to us. And so if we can win our case, we effectively can get a finding that helps everybody. And you have to go
Brian,
to the court.
speaking of the findings, could you talk about the significant findings in that particular court issue?
Sure. What we found, what the court held, we basically got a class certified of over 50,000 people around the country, all of whom had denials by UBH on these guidelines. We then actually went to trial, and we had a trial before the judge, and the judge found specifically that UBH's internal guidelines violated the plan documents and were inconsistent with generally accepted standards. And there is under a federal statute called ERISA, which is the Employee Retirement Income Security Act. So those are always the issues with statutes. But this statute establishes that a company, an insurance company that makes decisions about benefits, is a fiduciary. And a fiduciary means you owe a high level of duty. It's not just an arm's length business transaction, but a high level of duty that you owe to your insureds. And the court found that UBH had breached its fiduciary duties by applying these improper guidelines. And significantly, it laid out what it said were in fact the standards for generally accepted coverage, including that you have to deal with chronic conditions, you have to take into account all natures of problems, you have to look at what's the most effective level of treatment, etc. And those are the standards UBH was not complying with.
Brian, now, as I understand the decision from the court as well, is there was an interesting finding regarding the insurance company and the administrator running the potential guidelines.